Good afternoon. Good afternoon. You saw a while ago that I live streamed Chad Daybell. Well, I'm going to try something on StreamYard. Everything I tried this morning, it got screwed up. So I'm going to try the Karen Reed story. So it depends how the internet doing, my friends. We just have to wait and see. So I'm trying, and I want to thank TB. If you all don't know who TB is, it's Triumphs Beware. So I want to thank you all very much. I want to thank the subscribers I got to keep me going with these live stream court videos. Get me up to 1,000 subscribers. Show me how much you appreciate it. You know, I want to see how much you all like my, my channel. So let's see if I'm screaming. No, it seems like my cop picking string is locking up on me. It ain't doing nothing. I don't know if my banner's showing up on the bottom or not. Yep, it's showing up, people. Like, I guess they're taking a break. So I want to thank you all this. I think Karen Reed got set up. That's only that's only my opinion, people. So Humbug. Hey, somebody gonna ask for the StreamYard where you can come in up on my Hey, settle down. So I don't know when they're coming back from the break. No, we have to wait and see. Hey, remember, people, when you in my chat, I've told you this over and over. When you're chatting, keep everything PG because you got children in there with their parents or the guardian. Just remember that. You know, PG mean no bad words, no cussing, no anything, no hate groups, stuff like that. So I hope you all understand. So
Hear ye, hear ye, hear ye. All parties having anything to do before the Honorable First Justice W. Kanomi, now sitting in the Norfolk Superior Court within and for the county of Norfolk, draw near, give your attendance, you shall be heard. God save the Commonwealth and this good court, and you may be seated court down that section.
Okay, good morning, jurors. Jim. Yeah.
I'm sorry, jurors, could you stand one more time and raise your right hands? Do each of you solemnly swear you shall it according to your evidence and according to the law, so help you God? You can have a seat. Jurors, hearken to these indictments. 2282 CR 117001, Karen Reed of Mansfield in the county of Bristol, on or about January 29, 2022 at Canton in the county of Norfolk. Did assault and beat John O'Keefe with intent to murder such person, and by such assault and battery did kill and murder the said John O'Keefe, and is guilty of murder in the second degree and not in the first degree, in violation of General Law, Chapter 265, Section 1. 002, Karen Reed of Mansfield, County of Bristol, on or about January 29, motor vehicle upon a way as defined in Massachusetts General Law, Chapter 90, Section 1, or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, with a percentage by weight of alcohol in her blood of 8/100ths or greater, or while under the influence of intoxicating liquor, and did so operate said motor vehicles that the lives and safety of the public might be endangered, and by such wanton and reckless conduct so described, did cause the death of another person, to wit, John O'Keefe, in violation of General Law, Chapter 265, Section 13 and a half. 003, Karen Reed of Mansfield in the county of Bristol, on or about January 29, 2022 at Canton in the county of Norfolk, did operate a motor vehicle upon a way or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, and without stopping and making known her name, residence, and registration number of her motor vehicle, to go away to avoid prosecution or evade apprehension after knowingly colliding with or otherwise causing injury to John O'Keefe, such injuries having resulted in the death of said person in violation of General Law, Chapter 90, Section 24(2)(a)(2). To these indictments, the defendant has pled that she is not guilty and for trial has put herself upon the country, which country you are, and you are sworn to try the issue. If she is guilty, you are to say so. If she is not guilty, you are to say so and no more. Jurors, hearken to the evidence.
Thank you very much. Will counsel identify yourselves, please, starting with the Commonwealth.
Adam Lally for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Good morning, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor, and ladies and gentlemen of the jury. My name is David Yannetti, and I represent Karen Reed.
Good morning, Ms. Giannetti. Good morning, Ms. Reed. All right, good morning, jurors. Before we begin, I have to ask you 3 questions that I'm going to ask you every single time we meet. The first question is, were you all able to follow my instructions and refrain from discussing this case with anyone? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we were last in court? No. Everyone said no or shook their heads. Thank you. All right, jurors, I'm about to make some preliminary remarks to you to acquaint you with some of the legal principles, procedure, and terminology that you'll hear about during the course of the trial. But these comments are not intended to be a substitute for the more detailed instructions on the law, which I will give you at the conclusion of the case. This is the trial of a criminal case, as you've heard, and you've heard that the defendant is charged with second-degree murder. She's also charged with manslaughter while operating under the influence and leaving the scene after causing personal injury or death. I will describe in detail at the end of the case each of these indictments when I teach you the law, but briefly, murder is the unlawful killing of a human being. In order to prove the defendant guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt operating under the is an unlawful killing caused by wanton or reckless conduct while under the influence of intoxicating liquor. Again, these terms and elements of the crimes, including the additional crime of leaving the scene of an accident after causing personal injury or death, will be described for you in detail at the end of the case. Please remember that the defendant starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. So it's merely a formal manner of accusing a person of a crime to bring her to trial in the Superior Court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence alone requires you to find the defendant not guilty.
Remember,
The
people,
law does
they're
not
all
require a
innocent.
defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted.
Remember, people, any court cases on anybody's YouTube channel, remember they're innocent until proven guilty. That's the law. You know, sit back, watch it, take notes, and listen to the evidence from both sides. Just do that.
It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That is what we mean by proof beyond a reasonable doubt. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I'm sure you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that is what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to start making up your mind before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case
And
based on the
take notes.
evidence and the law instead of upon unsupported assumptions. Fourth, as you listen to the testimony about the people involved in this case, consider them as individuals rather than as members of a particular group. Finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, when I finish with these initial instructions, Mr. Lally will make his opening statement. Ms. Dianetti can choose to make an opening statement or not, because the defendant has no burden of proof and doesn't have to prove anything. Her lawyer doesn't even need to make an opening statement. An opening statement is a summary of what the lawyer expects the evidence at trial will be. It is intended to introduce the main issues in the case. Next, the prosecution will introduce evidence in support of the charges in the indictments. After that, the defendant may present evidence on her behalf if she wishes to do so, but again, she is not obligated to do so. Remember, the burden of proof is always on the Commonwealth to prove that the defendant is guilty. The law does not require any defendant to prove her innocence or to produce any evidence at all. After all the evidence, each side will have an opportunity to offer you closing arguments about what conclusions you might draw from the evidence. Like the opening statements, the closing arguments are not evidence. They're merely intended to help you understand the respective contentions of the parties. Finally, after all the evidence and the lawyer's arguments, I will instruct you in detail on the principles of law which you're to apply in your deliberations when you retire to consider your verdict. Your verdict must be unanimous. You see that we have many of you. We have 17 of you, and only 12 will ultimately decide this case. And that's done at the end of the case. We impanel so many jurors in a case that's going to take a long time in case something comes up and a juror can't complete his or her service. Let me talk briefly about our respective roles in this case. As the judge, my responsibility is to see to it that this case is tried in an orderly, fair, and efficient manner. It's also my function to decide any questions of law that come up during the trial and to instruct you about the law that applies to this case. It is your duty to accept the law as I stated to you, whether you agree with it or not. The jury's function. You folks are the most important people in this courtroom. You determine the facts of this case. You are the sole and exclusive judges of the facts. You alone determine what evidence to believe, how important any evidence is that you do believe, and what conclusions all the believable evidence.
Okay, people, if you've never been on a jury, take you a pad of paper, ink pen, or something like that, where you can take notes of the different witness, this and that. You know, that'll help you out. Just, be honest, make the right choice. But I got a feeling is what I know about this case. I've been watching it on, off and on. Somebody asked me after I'd done that Chad Daybell thing if I was going to do this. I said, well, I might do it tonight. But I decided to do it after I went to the mailbox, checked my mail and all this, and fed the outside cats, especially Mama Blackie. One of the babies from LB, put them a little canned food down there. They ate that like it was going out of style. So it takes a while for baby kittens to do that. Okay, you got my post office box at the bottom of the screen. It's streaming across there. And you can send me stuff in the mail, like maybe T-shirts that buckle up, it's the law, or YouTube, or so, canned cat food, cat treats, stuffed kitty cats, stuff like that. If you watch What the Hells, they get stuff in the mail all the time. So let's get back to this
Evidence
good-looking
leads you
lady.
to. You will have to consider and weigh the testimony of all the witnesses who will appear before you, and you alone will determine whether to believe any witness and the extent to which you believe any witness. You can believe all of what a witness says, some of it, or none of it. It's entirely up to you. It is part of your responsibility to resolve any conflicts in the testimony that may arise during the course of the trial and to determine where the truth lies. Ultimately, you must determine whether or not the Commonwealth has proved the charges beyond a reasonable doubt. The lawyers have their own important role in this trial. They are, of course, advocates. Their job is to bring to your attention the evidence and arguments that best support their position. They may also object to evidence offered by the other side that may not be admissible under our rules of evidence. Similarly, we may engage in sidebar conferences over here out of your hearing. They're not intended to keep secrets from you, but to allow the lawyers a little more time to argue their points so that I can rule on what you may consider as evidence. If I agree with an objection to a question during trial, I will use the term sustained. You are then to disregard that question, and you're not to speculate as to what the answer might have been. In the same way, you are to disregard any evidence that I tell you is stricken from the record. If I reject or overrule an objection, I will allow the witness to answer the question, and you may consider that answer. But you're not to give that answer any more weight than you would have had no objection been made. Please do not hold it against the lawyers if they make an objection. That's part of the lawyer's job. The lawyers have to let me know when there's a potential issue about the admissibility of certain evidence of law under our laws. You must decide this case solely in the evidence presented in the courtroom, and this will include the sworn testimony of witnesses and may also include exhibits that are admitted into evidence, any facts which I tell you may have been agreed upon by both sides, and any facts which I indicate to you that you may take as a matter of common knowledge. Questions to witnesses, no matter how artfully phrased, are not evidence. Only the answers that you receive from the witnesses who are testifying under oath are evidence. If one of the lawyers or I refer to some part of the evidence that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. In this case, I'll allow you folks to take notes. Any jurors who wish to take notes during the course of the trial, except during opening statements and closing arguments, because again, those aren't evidence, we'll hand out notebooks after the openings this morning so that you can take notes. They'll be provided to you daily. Your notebooks will be collected every day. They'll be kept locked up and confidential, and they're destroyed at the end of the trial. You're not required to take notes. The choice is completely up to you. Some jurors may feel that notes are helpful, particularly if the case involves many witnesses or complicated issues. Notes also can help you to remember specific testimony or evidence, such as times, places, dates, names, relationships, events, distances, things of that nature. Other jurors may feel that note-taking is a distraction and may interfere with hearing and evaluating the evidence. If you do take notes, I suggest you keep them brief. They are not and cannot be considered official transcripts of the trial testimony. However, bear in mind that although the court reporter is recording everything that transpires here, we do not have the capability of providing you with the transcript of the testimony at the conclusion or any time during the trial. So you will have to rely on your own memories of the testimony, perhaps supplemented by your notes. Regardless of whether or not you take notes, remember that how a witness testifies may be just as important as what he or she says. Therefore, your observations of the witness's appearance and demeanor on the witness stand may play an important part in your assessment of his or her credibility. So please do not let your note-taking distract you from an appreciation of all the evidence. Now, I'm going to address the issue of public interest in this case again, and the duty of this court and this jury to adhere to the rule of law because it is so very important. Remember, John Adams said that we are a government of laws, not of men, and that the law must be deaf to the clamoring of the public. He meant that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with intensity, but without the benefit of having heard or seen any evidence to our system of justice. This jury will decide. This jury selected for this trial will hear and judge the evidence. You will decide what the facts are, and where the evidence is contested, you will determine where the truth lies. Ultimately, this jury, you folks, will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this trial will be decided by you, an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So, while public comment will help, this means that during the trial, until you retire to deliberate, you must not discuss this case with anyone. This includes family and friends, and even your fellow jurors, nor should you allow anyone to communicate with you about any aspect of this case. You must not conduct any independent research about this case, the matters in this case, the individuals involved in this case. In other words, you must not consult the internet, including social media, and do anything else to find out any information from any source outside the confines of this courtroom. As best as you recognize them, please have no contact with any of the participants in this trial or anyone associated with either side, including the lawyers. Please do not visit any locations that may be mentioned during the trial. We will go on a view and I will discuss that with you before we go. Remember, you were instructed that you must not, and you assured us that you would not, read, watch, or listen to any account of any aspect of this case in any news media or from any other source. It is critical that you follow that instruction, as hard as it's going to be. Finally, please continue to keep an open mouth. Now, I know that you will try this case according to the oath that you have taken as jurors. When you took that oath, you promised that you would well and truly try the issues between the Commonwealth and the defendant according to the evidence and the law. If you follow that oath, approach this case with an open mind, and make your decisions fairly and without prejudice, bias, or sympathy for anyone, then you will arrive at a true and just verdict.
No wonder
And that's
people
what we
don't
ask
want to
of
get
you.
on a jury.
So with that, opening statements, and whenever you're ready, Mr. Lally.
Thank you, Honor.
And ask only that you keep your vote, please.
Good morning. Your Honor, is telling you, this is one of the what I'm going to, the number of different witnesses that were listed out as far as potential witnesses. So what I here I can through those that to navigate. So please do. Grew up in Braintree. He was 46 years old when he passed. He was the son of John O'Keefe Jr. and Margaret or Peggy O'Keefe. He was a brother to Paul O'Keefe and to his sister Kristen Furbush. Kristen was married until John's brother-in-law was a man named Stephen, and they had two children who were very young in 2013. Now, in 2013, Kristen, unfortunately, tragically, passed away, succumbing to cancer in November of 2013. Within months of that, Mr. O'Keefe's brother-in-law and Kristen's husband, Stephen, passed away as well. Now, initially, when John O'Keefe's sister passed away, sort of the initial plan for that situation was that John O'Keefe was going to move in with Stephen Furbush and the kids and assist as far as raising them. And then when Stephen passed away a few months after his wife, before those plans could be finalized, John O'Keefe then moved in with his niece and nephew and assumed the parental role and assumed legal guardianship.
Man, this is a bunch of bull. Who in that blanky blank wants to hear about his mom, dad, brothers, sisters? Get on with the facts. Man, the jury hates to listen to all that bull crap. You know, I would. That'd PO me off, people, if I was on the jury. You know, because of the a-hole putting everything in it, that'll make me mad. Let's get to the facts of the case, not the family history. Lordy.
With respect to both of those children. Now, he was assisted in this by a great number of people within the town of Canton, where the Furbushes lived, and where John moved into the home with the two children there. There were other parents within the neighborhood, other parents within the children's age group. You'll hear from a number of them over the course of this trial, but they included Mrs. Carrie Roberts and Mrs. Jennifer McKay. They helped Mr. O'Keefe out during those initial stages and during the time that he assumed this role. He also got help from his work. John O'Keefe was a proud member of the Boston Police Department, had been for many years. He had been a patrolman prior to moving in with the children and assuming this role. Boston Police Department helped him greatly as far as conditioning him to more of a desk role, working in the sex offender unit. With more regular hours to sort of assimilate himself to this new life and this new role that he assumes with these children. Initially, John O'Keefe lived in the house with the kids. However, in 2018, they moved into a new home, sort of a new home that they could have as their own. That home is located also within the town of Canton, sort of on the Stoughton side of Canton at One Meadows Avenue. John O'Keefe raised these children, assuming guardianship for them for about 8 years. His niece, who was the elder of the two, was about 14 at the time. John died. His nephew was about 11 years old at the time. John O'Keefe died.
StreamYard Let's try this again, people.
Strip of Washington. Now, they get Mr. O'Keefe and Mr. Camerano leave the girls at home. They then go to see if McCarthy is arriving there sometime between 7:30 and 8 p.m. They eventually cajole another friend of theirs, Mr. Kurt Roberts, to come out to the bar and join them as well. And there's some other people that are located within the bar, including Mr. James was at the bar that night.
It's froze. I can't. I damn StreamYard. Sorry, people. When it starts to upset me, I be getting off.
Swelling of his eyes. And other injuries that he observed, they observed redness from the cold that he had been lying out in for some time. You'll hear the testimony from these firefighters: Timothy Nuttall, Anthony Filmati, Matthew Kelly, Francis Walsh, Katie McLaughlin, and Greg Woodward.
Or
At least from 3 of those firefighters, you'll hear testimony anticipates detailing statements that the defendant made to them when they had asked about the origination of some of those injuries. The defendant stated repeatedly, "I hit him, I hit him, I hit him." Mr. O'Keefe then taken from the front lawn onto what they call a scoop stretcher. As he's doing that, I anticipate you'll hear Ms. Roberts' testimony that despite the 6 inches of snow approximately that was on top of Mr. O'Keefe's body and the snow throughout the roadway, front yard, everywhere around where he was, there was grass underneath Mr. O'Keefe, where his cell phone was located underneath his body as he lay on that front lawn. He was then transported by firefighters Kelly, Flamati, and Nuttall, as well as an ambulance being driven by firefighter McLaughlin to the Good Samaritan Medical Center. Once there were some observations, and you'll hear testimony from Dr. Justin Rice from that facility as far as observations consistent with what I anticipate you'll hear from those firefighters. But then there's a certain warming procedure that they go through trying to bring his body temperature up. Because when Mr. O'Keefe arrives at the Good Samaritan Medical Center, his body temperature is 80. And after those resuscitative efforts, O'Keefe is eventually pronounced by Dr. Rice at approximately 7:50. Shortly after that, when this is now going to go, Mr. She indicates that the last that she saw Mr. O'Keefe, they had gotten into an argument before he had gotten out of the car. Conditions that are still ongoing. Certain pieces of evidence that they located in and around the area where Mr. O'Keefe's body was found. It was over a sleepover. They weren't aware that Mr. Camarano had come over to the residence on Meadows Ave and attended when the defendant left to go looking for Mr. O'Keefe. So unaware of that, they go do a well-being check at approximately 8:22 in the morning. And they also have cruiser camera video attached to their cruiser. And you'll see that video. On 8:22 in the morning, they pull in directly behind where eventually you'll hear Mr. McCabe left the defendant's vehicle after driving it from courthouse to Meadows Ave and searching Mr. O'Keefe. And you'll have that footage, and you'll be able to see the back of the defendant's vehicle, specifically the right rear tail light of that. From Mr. Sullivan. Also, they were all present with the defendant and Mr. O'Keefe at C.F. McCarthy's. You'll hear testimony from another number of at the waterfall. The waterfall is a bar located across the street, essentially on Washington Street, somewhere that Mr. O'Keefe and the defendant went after leaving C.F. McCarthy's at approximately 11 p.m. Now, from that establishment, you'll hear from Rebecca Traers, who was working in community police, who were friends of friends, who had known Mr. O'Keefe through their daughter around the same age as Mr. O'Keefe leaves. Mrs. Kolakaitis had some conversation with the defendant that evening, as well as herself and Mrs. McCabe at the waterfall. She left around the same time at area as Mr. O'Keefe and Ms. Reed did.
Get down.
In Ms. Reed's car, and she observed
Lexi, get down.
the defendant walking toward the defendant's vehicle, and specifically the defendant walking towards the driver's side of that.
I don't want you all on this
Now,
tape.
you'll hear testimony from a Christopher and Julie Albert, who were people who were at one point of Mr. O'Keefe. They knew him well from being neighbors of him. Christopher Albert owns a pizza shop, also located within that Cannon Center area. Mr. O'Keefe, earlier in the day on the 28th, had been into that pizza shop along with his nephew to get his nephew a slice. Mr. O'Keefe had some conversation regarding what they were doing that night, and it's Christopher Albert who actually texts Mr. O'Keefe and indicates that they're over at the waterfall and that he should come over shortly before Mr. O'Keefe and the defendant make their way from C.F. McCarthy's over. Now, Christopher Albert left directly from the waterfall, and when Julie Albert had left earlier in the evening, there was a band playing at the waterfall that night. Julie Albert started to get a migraine. She left before most of the group. Included within that group, sort of how they came to the waterfall, the Albert family, her sister-in-law, Nicole Albert, as well as her niece, Caitlin Albert, her niece's boyfriend, Mr. Tristan Morris. And they had had dinner at the waterfall earlier in that evening. Now, Nicole Albert lives at 34 Fairview Road. She has a husband named Brian Albert, who's also a Boston police officer. Brian Albert had gone with a friend of his, who's also in law enforcement, a man named Brian Higgins. And they had gone separately, but had come home together from a funeral for a fallen police officer in New York City. Came home early to sort of beat the weather, and eventually they meet up with Brian Albert's family at the waterfall. Now, Tristan Morris, who was Caitlin Albert's boyfriend, had left the waterfall at some point in the evening. He then returns later to the residence on Fairview Road and picks up Caitlin Albert, brings her home. All of this is in relation to Brian Albert and Nicole Albert's son, Brian Albert Jr., whose birthday was coming up the following day, the day of the snowstorm on the 29th. He had a number of friends that had come over that evening to celebrate his birthday with him. Now, among those friends were here for a good portion. Now, those individuals from the waterfall that leave and then come to 34 Fairview, they do so sometime shortly after midnight. Shortly after midnight is was starting to come down. Snow was starting to stick to some degree to roads, to the front lawn, to grassy areas around the town. Now, from that group, the group that goes back is obviously Brian Albert and Nicole Albert as they live there, Caitlin Albert, because it's her parents and her boyfriend picking her up, as well as Jennifer McCabe, who is Nicole Albert's sister, and her husband, Matthew. They go back to that, and there's an open invitation to essentially anybody that's there. John O'Keefe takes them up on that. There are certain text messages and phone conversations between John O'Keefe and Jennifer McCabe as to where this house is located, as he's never been there before. And then he and the defendant drive in the defendant's vehicle to 34 Fairview. And once there are several witnesses from within the home that observe the vehicle parked in. So I mentioned earlier there were two females that were with Brian Albert Jr. at the house, one of them being Julie Nick. At some point, she had called her brother, Mr. Ryan, for a ride home. He then gets a ride from his friends, Ricky Antonio, as well as his Mr. Nagel's girlfriend, Heather Maxson, that's riding in the back of Mr. Antonio's pickup truck. I say that because they arrive at Fairview Road around the same time as the defendant. The defendant is coming in from one direction. The pickup truck with the Nagel brother is coming in from another direction. The pickup truck that the Nagel brother is riding in flashes its lights, signaling the defendant to go. She goes first. They follow in behind, and lo and behold, they end up at the same house. They parked in the area of the driveway, and the defendant in her black Lexus SUV parks a little bit further up. Different people from within the pickup and different people from within the house observe that Lexus SUV in one location, pull up a little bit further, and then pull up a little bit further until it's in the area of that fire hydrant, of that flagpole, where Mr. O'Keefe is located the following morning. Now, from their position, I anticipate the testimony that you're going to hear is that Heather Maxson from that pickup truck observes a male passenger and a female operator when the pickup truck operator flashes those lights at the vehicle as they're facing each other before they pull down. Fairview. What you'll hear also, I anticipate from all.
No.
three of those individuals in the pickup, and Julie Nagel, who comes out to the pickup to talk to the brother, is that no one ever exits that vehicle. There are no footprints around that vehicle. There's no damage that they observed to that vehicle at that time. Again, it's just started to snow. Things aren't sticking really too much at this point. Julie Nagel has a conversation with her brother, decides that she's going to stay at the house longer, so arrangements for a ride home, and the pickup truck leaves from that point. As they pass by, they observe a female operator matching what I submit as a description of the defendant. From all of those people within that house that evening, none of them at any point in time observed John O'Keefe come into the house. They see the vehicle out front, they see the vehicle pull away, and they just assume that they left and that no one was coming. We hear testimony from other individuals who were at the house that night, including Colin Albert, who was bringing people over for his birthday. He's leaving the house around the time that the initial people coming back from the waterfall, which includes the homeowners and Mr. Higgins, are sort of coming into the house. At that point, Colin Albert is leaving. He's getting picked up by a young lady named Allison McCabe, who is Jennifer and Matthew McCabe's daughter, who's also friends with Colin Albert and also cousins of Brian Albert Jr., who's within the home celebrating his birthday. As I mentioned, you'll hear testimony from Matthew McCabe and from Jennifer McCabe in regard to their observations that particular evening, both at the waterfall as well as at the residence on Fairview Road. And then you'll hear testimony in regard to a phone call. A phone call that Jennifer McCabe receives from John O'Keefe's niece at approximately 4:53 in the morning. She answers that phone call, speaks to the niece briefly, and the niece hands the phone over to the defendant. Now, you'll hear testimony from the niece as well. About 4:30 in the morning or so, the defendant came into her room in a frantic state, saying that Mr. O'Keefe had not come home.
Lay down. Lay
So
down.
initially, when the defendant is talking to Ms. McCabe, she indicates to Ms. McCabe that the last time she saw Mr. O'Keefe was at the waterfall. Eventually, as Ms. McCabe is waking up, she reminds the defendant that she not only saw them leave the waterfall around the same time as herself, but also saw the vehicle, the defendant's vehicle, outside of the home on Fairview Road. Eventually, the defendant, while driving around, this will
Why you gotta get on my chest?
testimony,
I know you love me, Black.
she's driving around in that morning. She's calling a bunch of number of different people, friends of Mr.
Yeah,
O'Keefe. She's
I love you too.
So
Come on, get out
she
here.
also calls Ms. Roberts. So Kerry Roberts receives a call about 5 a.m. from the defendant indicating that Mr. O'Keefe did not come home, indicating that he got hit by a plow or
Down.
dead. Ms. Roberts then gets ready. Mr. McCabe is getting ready as they're all sort of planning to go out and look for Mr. O'Keefe and see if they can locate him. They call numerous times. You can see that within the text messages and the phone extractions from a variety of people's different calls throughout the course of this trial as well. So eventually, the defendant comes to Ms. McCabe's home.
Margaret.
Indicates at some point prior to that,
Down.
she has cracked tail.
Alex, down.
Ms. McCabe then gets in the driver's seat due to the defendant's frantic state. Ms. Roberts is there as well. Ms. Roberts follows Ms. McCabe driving the defendant's vehicle back to Mr. O'Keefe's residence on Meadows Ave, checks on the niece. The defendant then shows both Ms. Roberts and Ms. McCabe the damage to her right rear taillight, which is essentially missing a number of different pieces from that right rear taillight. They then proceed off to drive and see if they can locate Mr. O'Keefe. The defendant is insistent that they go to that residence on Fairview Road. Again, they're driving down there in the dark, in the snow, in the wind, in the blizzard. As they approach towards that residence, there is one person. So they're seated within the vehicle. This is Ms. Roberts' vehicle. She's driving. Mrs. McCabe is in the front passenger seat. And the defendant is in the rear passenger seat. The defendant is the only one who sees Mr. O'Keefe. He yells and screams at Ms. Roberts to stop the vehicle. Ms. Roberts and Ms. McCabe, I anticipate, will testify that they did not see Mr. O'Keefe, not only as they were driving past him, but even after they got out of the vehicle until the defendant gets out of the back seat and makes a beeline essentially right over it, then dials 911. And shortly after that, the officers and the firefighters arrive on scene. Now, while they're waiting there, station with the defendant asks Ms. McCabe to look up on her phone how long someone has to be out in the cold to die from hypothermia, or something to that effect. And you'll hear some dispute as to when that search was made. You'll hear testimony from 3 different forensic extraction experts, Nicholas Carino, Ms. Jessica Hyde, and Mr. Ian Whitford, who you'll hear about a lot of these things called extraction reports from cell phones. And the extraction reports are done with a program called Cell. Mr. Whiffen is someone who writes that software for Cell. I anticipate you'll hear from each of their testimonies that Google search that was done on Ms. McCabe's phone was done at the same time frame that she indicates the defendant requested her to do it, and that at 6:23 and 6:24 morning. You'll hear testimony from Ms. Roberts, Ms. McCabe, the firefighters, and the responding Canton police officers about a repeated phraseology that the defendant stated while there, asking again and again in regards to Mr. O'Keefe, is he dead? Is he dead? You will also hear testimony, as I indicated, about treatment that she received at the Good Samaritan Medical Center, and that would involve testimony of Ms. Daisy Ormseth, Ms. Kathleen Wilford, and Dr. Gary Fowler. You'll hear testimony from a number of different analysts from the State Police Crime Lab and from some other laboratories as well. Included within that will be Mr. Nicholas Roberts, and Ms. Maureen Hartnett, Mr. Andre Porto, Ms. Ashley Vallier, and Ms. Christina Hammond, those all being from the State Police Lab. You will hear testimony in regard to an incident which occurred earlier in January, right around New Year's. Mr. O'Keefe, the defendant, and the children have been invited with a much larger group, approximately 70 people or so, to spend New Year's in Aruba. This is a trip that was organized by a friend of Mr. O'Keefe's named Laura Sullivan. We'll hear testimony from her, as well as from her sister, Ms. Marietta Sullivan, as well as you'll hear testimony from the 2 children in relation to this. And essentially, day 2 or so of this trip, Marietta Sullivan, the sister of Laura, is walking through the lobby and she runs into Mr. O'Keefe. This is someone she refers to as godfather, because John O'Keefe is also the godfather of Laura Sullivan's son. Runs into him in the lobby, gives him a hug, and sort of pointing him in the direction of where she believes he's going into his room. The defendant is in the area. The defendant starts yelling and screaming and swearing at Ms. Sullivan. Ms. Sullivan responds in kind. Essentially, for the most part, the Sullivan sisters see very little of Mr. O'Keefe throughout the remainder of their trip to Aruba. And we also hear testimony from the children that shortly after this, or immediately after this, there is approximately 20-minute screaming match going on between Mr. O'Keefe and the defendant within their hotel room in front of the children. Now, you'll also hear testimony from the defendant's phone in regard to, and from another individual's phone in regard to that Aruba, in regard to text messages of an amorous nature that she had with Mr. Brian Higgins, who was at the waterfall, and also at the residence on 34 Fairview, because he was friends with the homeowner, Brian Albert, but he was also friends with Mr. O'Keefe and had also met the defendant. And throughout the course of those amorous text messages, there is references that the defendant makes to that incident in Aruba, as she purports it to be Mr. O'Keefe cheating on her. She insists that he was making out with Marietta Sullivan in that lobby as opposed to her giving him a hug, and makes repeated reference to that within the contents of those text messages as well. Now, you'll hear testimony from a number of different other individuals. Mr. Michael Trotta, who has a supervisory role with the Canton Department of Public Works. You'll hear from Mr. Louis Jutras, who has a supervisory role with regard to IT, in regard to certain video that was recovered from the town of Canton, as well as from a temple located along the route that the defendant traveled, both away from Fairview that evening, as well as to Fairview from the waterfall, away from Fairview to Mr. O'Keefe's residence on Meadows. And then later in the morning at 5 a.m. Because if you recall, Ms. McCabe, I anticipate, would testify that she receives the call from the defendant about 4:53 in the morning. The defendant then drives around Canton for some perceptible half-hour or so period of time prior to even getting to Ms. McCabe's house. And what I submit the evidence, or what I anticipate the evidence will show, based on sort of the tracking of her phone records, testimony you'll hear from Lieutenant Brian Tully of the state police, from these bulky records and RTT accounts, that the defendant, while she's using her phone, is driving in the direction of Fairview Road prior to going to Mrs. McCabe's house, where she meets Ms. McCabe and Ms. Roberts. Now, again, you'll hear testimony from a number of different, you'll hear from Chief Michael Proctor and Sergeant Yuri Mechanic of the state police. You'll hear from Lieutenant Brian Tully. You'll hear some testimony from Trooper Joseph Hall, who's in a specialized unit within the state police called ARS for short, but essentially a collision analysis and reconstruction section within the Massachusetts State Police. His examination of the vehicle, his examination of the scene, his examination of specifically some Toyota texture, because Lexus is essentially owned by Toyota or vice versa. So there is some data that he's able to recover from that and back the vehicle up based on its known locations and travel, key cycles, and essentially opines, anticipate he'll opine that around 12:45 in the morning, when the vehicle was in front of the residence on Fairview, that for some perceptible period of time, that vehicle travels over 60 feet in reverse at over approximately 24.2 miles per hour. Now, you'll hear testimony, as I said, from a number of different troopers, as well as from a number of different analysts from different labs. Included within that is Ms. Maureen Hartnett, who collected items from the vehicle, the defendant's vehicle, including the taillights, sort of housing from that vehicle, pieces of the taillight that were discovered in sort of front grass and front street area. There is a specialized team called CERT team. You'll hear from Lieutenant Kevin O'Hara, who has a supervisory role in relation to that. And then later on that day of the 29th, he, along with Lieutenant Tully and a number of different members from his CERT team, were searching for evidence within the mounds of snow in front of that house, as the blizzard is still ongoing at this point through sort of the afternoon hours. Among the items that they locate is a sneaker. When Mr. O'Keefe is transported to the hospital, he's found to only have one sneaker on his feet. They find the other sneaker in that area of the body. They find various pieces of taillight. And as is wont to do, over the course of the following days, the temperatures rise, there's a rainstorm that comes in, and the snow melts. Over those successive days, there are additional pieces of taillights that are eventually discovered in that area of the front lawn in the street. Now, from these different pieces, Ms. Hartnett has also locates a cocktail glass that's located on the bumper or the rear area of that scene, and she locates a human hair on the back of that defendant's vehicle as well. Now, the cocktail glass on the bumper, you'll also see surveillance video from the waterfall, and Mr. O'Keefe is observed on that surveillance video essentially walking out of the waterfall with a cocktail glass in his right hand. Same right hand that has minor injuries to it, and the same right hand that's attached to his right arm that has the abrasions and lacerations that are observed by the paramedics, that are observed by the doctors at Good Samaritan, and are observed by the medical examiner as well. You'll hear testimony from another analyst, Christina Hanley, about the forensic consistency between a drinking glass that was in the defendant's bumper and the drinking glass pieces that were found on scene at 34th Fairview. You'll hear her testimony in regard to pieces of red and clear plastic that were microscopic in size that were found within Mr. O'Keefe's clothing, consistent, in her opinion, I anticipate she'll testify, with the same pieces of plastic contained within the defendant's taillight. You'll hear from an Ashley Valley, who works for the lab as well, and how she fit the various pieces of broken taillight from the scene together and over that taillight housing, finding them to be consistent with each other as well. You'll hear testimony from Andre Porto, who's essentially DNA analyst for the lab, and samples that were DNA samples that were taken from the taillight, from the clothes of Mr. O'Keefe, and the broken drinking glass that were consistent with Mr. O'Keefe. Those items were also sent, the taillight pieces, taillight DNA was also sent to an independent lab, Bodie Technologies, located in Lorton, Virginia. And you'll hear from an analyst there, Mr. Nicholas Bradford, indicating that the DNA on the defendant's taillight, in his opinion, is consistent with that of Mr. O'Keefe and inconsistent with Trooper Proctor and Sergeant Buchanan, who were the two preliminary investigators and primary investigators when it came to this case. You'll also hear from this test chart from that Bodie Laboratories in regard to some mitochondrial DNA that she examined in regard to that hair that Ms. Hartnett found on the bumper of the car, and her opinion that it was consistent with that of Mr. O'Keefe as well. Lastly, you'll also hear from Dr. Irene Scortibello and Dr. Renee Stonebridge of the Office of Chief Medical Team in regard to their various examinations. Dr. Stonebridge is a neuropathologist. She essentially examines brain findings. Dr. Irene Scortibello is a forensic pathologist who does the sort of autopsy and medical examination of Mr. O'Keefe's body. You'll hear about the variety of sort of injuries that she observed over Mr. O'Keefe's body from. In particular, you'll hear testimony in regard to lacerations to the right back of his head. You'll hear testimony in regard to an initial sort of skull fracture that occurs to the back of his head, and then sort of a radiating skull fracture that goes throughout his skull, which then leads to a subdural hemorrhage, or essentially bleeding on the brain and swelling of the brain, which then
Jack
ecchymosis,
is not a law
which then sort of
expert
leads to
doctor.
swelling of both of Mr. O'Keefe's eyes that was observed by the initial response.
In my book, that is.
You will hear various testimony about sort of issues in regard to his pancreas, how that's indicative of hypothermia. Now, again, as I said, this is the first of two times that I have an opportunity to address you directly. And I thank you very much for your attention today, and I thank you for the anticipation of your close attention as we go through all of the witnesses and all the evidence in this case. That second time that I do here to address you, what I'll be asking you to do, based on the evidence, and again, as the board has instructed you, you are the sole arbiters of the facts of this case. You are the ones who find what the facts, I reiterate that, facts, and what the evidence demonstrates this. What I submit to you with that is that the defendant, Karen Reed, is guilty of murder in the second degree, striking the victim, Mr. O'Keefe, with a car, knocking him back onto the ground, striking his head on the ground, causing the bleeding in his brain, swelling, and then leaving him there for several hours in a blizzard with temperatures in the teens, wind swirling around, snow piling up on his body until she comes with Mrs. McCabe and Mrs. Roberts just after 6 a.m. And that she is also guilty of vehicular manslaughter, operating under the influence of liquor, and that she is also guilty of leaving the scene after causing death. Thank you very much for your time.
All right. Thank you, Mr. Lally. Mr. Netti?
Thank you, Your Honor. May it please the court.
Well, he's worse than a woman.
Karen Reed was framed. Her car never struck John O'Keefe. She did not cause his death. And that means that somebody else did. You will learn that it was no accident that John O'Keefe was found dead on the front lawn of 34 Fairview Road in Canton on January 29th of 2022. You will learn that at that address lived a well-known and well-connected law enforcement family in Canton, the Alberts. Because the Alberts were involved, and because they had close connections to the investigators in this case, Karen Reed was framed for a murder she did not commit. Good morning again, ladies and gentlemen. As I previously told you, my name is David Yannetti. I'm an attorney with an office in Boston. Together with attorneys Alan Jackson and Elizabeth Little, it is truly my privilege and my honor to represent Karen Reed during this trial. From a very early juncture in this case, You will question the Commonwealth's theory of the case. You will question the quality of the Commonwealth's evidence. You will question the veracity of the Commonwealth's witnesses. And you will
Ow.
question their shoddy and biased
Go lay down.
a
Alex,
faulty
come
investigation that led to Karen Reed sitting here.
Oh, Lord.
You will learn, in short, that the police did
No
know
wonder I'm
the real
getting abused by
investigation
Kitty
of this
Cat.
case, and you will question why.
Come on.
You'll question why the investigators had such tunnel vision. You will question why they focused solely on Karen Reed, someone with no ties to the Canton Police Department, as opposed to the well-known and well-connected
lay
Albert
down,
family
Blackie.
of Canton. Family that
Don't
was
try to
never
butter
treated
me up.
as suspects by the investigators in this case. Boston police officer John O'Keefe was found mortally injured on Brian Albert's front lawn. His body was in full view and almost right below Brian Albert's bedroom window on his front lawn. He was found wearing only one sneaker. You'll learn that Brian Albert was a Boston police officer as well, and that he was a trained first responder. Brian Albert was notified that another police officer was injured and unresponsive on his front lawn, and Brian Albert did nothing. His
Why?
sister-in-law, Jennifer McCabe, and other civilians were on his property that morning after John O'Keefe's body was found. Police, EMTs, firefighters, police cruisers, and an ambulance, fire truck, lights flashing. And first responder Brian Albert never came out of his house.
Why was it? I
Equally
want to know
important
that.
will be the fact that the lead homicide investigators never went inside the Albert home that night. You'll learn that Brian Albert's brother, Kevin Albert, is a Canton police officer. It was obvious very early on that the Canton police should not be investigating the death of a man found on the property of the brother of a Canton police officer. So it was decided just about from the start that the Massachusetts State Police should take complete control of this investigation because the Canton police were conflicted out. Now,
I
that
agree.
sounded good at the time, but you'll learn that two major problems arose. First, despite the fact that they obviously had a conflict of interest, the evidence will show that the Canton police still had their hands in this investigation. You will find it astounding, but Canton police officer Kevin Albert, the reason for the conflict of interest in the first place, was continually updated about the status of this investigation while it was going on.
Okay, my question, let's pause it for a minute. Since that was in front of the police officer's house, and he's, like he said, and after all these other police officers showed up, fire department, all this, why didn't he come out the house? I'm not a cop. I don't have any law degree. But my suspicion, maybe he had something to do with it. We just have to wait and see. People, hit the thumbs up, hit the subscribe bell. Let's get me over 500 subscribers. No, I take it back. Let's get me 1,000 subscribers. Let's get over 4,000 watch hours. Come on. Remember your old time YouTubers that been on close to a year. You know how it was when you started. You maybe didn't have the right content. So people start subscribing your channel, you probably subscribe back to their channel. I'm asking all you YouTube, please subscribe to my channel. I guess this is going to help me out. Since I'm figuring out how to share StreamYard. I think what my problem was, people, I was going back to StreamYard where I could read my comments. And that's where I think I was having a problem. But since I left it there on YouTube, I don't think I've had any problems. But I want to thank all of you, TB and all y'all. Thank you for subscribing. Thank you for the thumbs up. God bless you all.
Second, and equally troubling, is that the lead state police detective who was assigned to this case was a man named Michael Proctor. Michael Proctor, you will learn, is one of the many people in Canton with deep ties to the Albert family. Michael Proctor's own mother refers to the Alberts as the Proctor's second family. His own sister's wedding, Michael Proctor was in the wedding party with Colin Albert. And he sat at the head table of that wedding with members of the Albert family. That's the man who was chosen to lead the investigation into
I
this
say
suspicious
there
death
is a conflict of
on the property
interest.
of Brian Albert. That's the man who gave updates to Canton police officer Kevin Albert, while the state police were supposed to be investigating what had occurred at his brother Brian Albert's house. You'll learn that right from the jump, Michael Proctor predetermined the outcome of this case. Never stepped foot inside the Albert home on January 29th, 2022. Never checked out whether there were any signs of struggle inside that home. He never called for crime scene technicians and other specialists to look for blood or other trace evidence within the home. He never asked Brian Albert for permission.
Okay, people, that called, I think, tenant evidence, since they didn't do it. From what I hear from both sides, the prosecutor and the defense, I'm going to say not guilty now. Let's just see if I'm right through the days of the trial.
To go in the home and take a look around. Michael Proctor never applied for a search warrant to go in that home. Instead, he focused immediately and exclusively on Karen Reed, the outsider. You will learn that no one in the Proctor family has ever called the Reed family their second family. No one in the Proctor family had been in a wedding party with anyone from the Reed family. Karen Reed was a convenient outsider. She was most definitely not from Canton. So how did Michael Proctor feel about her? How did he treat somebody he was investigating at a point in time when he should have been keeping an open mind and focusing on obtaining all possible evidence so that he didn't miss anything? Well, you will learn that on the very day that John O'Keefe was found dead on Brian Albert's lawn, Michael Proctor was texting with his high school buddies about this supposedly secret investigation using his personal cell phone. He was revealing information about this investigation to his friends, assuming that nobody would ever find out what he was doing and what he was saying. And he was revealing his true thoughts about Karen Reed to his friends, not what he put in his sanitized police reports, his true feelings. To his friends whom he trusted, and in text messages that he never thought would come into the hands of the defense in this case. Lead investigator Trooper Michael Proctor, right from the start, called Karen Reed names you would reserve only for your worst enemies. He told his friends that he hoped that she would kill herself. He told his friends that he had seized her cell phone. And you will learn that he knew he shouldn't have been accessing any content on her cell phone because he knew there would likely be attorney-client communications on between Karen and me at that time. He knew that he was supposed to wait for a search warrant or other permission from a judge in order to go through that phone. But you'll learn that he went through the phone anyway, without permission. And you'll know that he did because he told his high school buddies that he was searching her phone for nude photos of Karen Reed. And he was disappointed he hadn't found any yet. That is the professional and unbiased investigator who was chosen to lead the investigation into the death of John O'Keefe. You will learn that one of Michael Proctor's high school friends commented to him that with a dead body on the front lawn, the homeowner in this case is surely going to catch a lot of grief. And do you know what Michael Proctor's response to that was? One word. Nope. And he explained why. Michael Proctor assured his buddies that the homeowner would not catch a lot of grief because, quote, the homeowner's a Boston cop too, end quote. That one sentence, ladies and gentlemen, in Michael Proctor's own words, will explain a lot to you about how this investigation was conducted. You will be able to evaluate whether Trooper Michael Proctor treated Brian Albert and his family differently because of who they are and their relationships between his family and theirs. You will evaluate whether this investigation was on the up and up. You will decide, as a result, the prosecution's DNA evidence is or is not in light of who controls it. You will learn that Michael Proctor's fingerprints are figuratively all over this case. His fingerprints are all over the Commonwealth's evidence. You will learn that Michael Proctor showed up at Karen Reed's parents' house in Dighton to interview her during the afternoon of January 29th, only hours after John O'Keefe's body was found dead on Brian Albert's front lawn. You'll learn that Michael Proctor had her Lexus SUV towed from her parents' home. But you'll also learn that he wrote a search warrant in which he falsified the time that he took that SUV. He swore under oath that the vehicle wasn't towed until 5:30 p.m. But you'll learn that we obtained surveillance footage that he didn't know we would get. And that surveillance footage exposed that Michael Proctor's words in that sworn affidavit were a lie. Michael Proctor had that vehicle for about 90 minutes before he claimed to have taken it. And folks, you will learn that the timing is important, very important. Because when John O'Keefe was first found on Brian Albert's front lawn, the police thoroughly searched that yard for potential evidence. And it wasn't just one officer, or two, or three. There were at least 4 officers that searched that front lawn. And that morning was the beginning of a snowstorm, but there wasn't yet much snow on the ground when they were searching that lawn. It was light out by the time they did the search, and it was getting lighter. And during that thorough search of Brian Albert's front lawn, the number of pieces of tail light that were found by a minimum of 4 officers looking for evidence was 0. It was only later in the day, when the snow was really starting to accumulate, that the police miraculously started to find pieces of taillight on the property. The police only started to find pieces of taillight after Michael Proctor had seized Karen Reed's car. They only started to find pieces of taillight after Michael Proctor had possession of her taillight. You'll learn that Trooper Michael Proctor then kept going back to the Albert residence after that day, and he claims to have kept finding pieces of taillight on multiple occasions on multiple different days. And in addition, a good week after John O'Keefe's death, Canton Police Chief Kenneth Berkowitz, an older officer on the brink of retirement with probably not the best eyesight, he supposedly was driving happened to be driving past Brian Albert's house. And by the way, Brian Albert is someone with whom Chief Berkowitz is also good friends. And this older man allegedly spotted yet another piece of taillight from his moving vehicle. This was yet another piece of taillight that was somehow missed by the trained specialists who had previously and thoroughly searched the property. Another piece of taillight that Proctor supposedly missed in the many times he went back to the property. Michael Proctor claims that he kept finding pieces of taillight right up until February 18th of 2022, which was nearly 3 weeks after John O'Keefe was found dead on Brian Albert's home.
Impossible. Somebody's
no
lying.
evidence that Karen Reed's taillight shattered at Brian Albert's property in the early morning hours of January 29th, 2022. To the contrary, you'll learn that when Karen left John at Brian Albert's house, she drove back to John's house on Meadows Ave across town in Canton. At John's home, where he lived with his 2 adopted children, Karen was drifting in and out of sleep, but she woke up for good in a panic sometime around 4 a.m. because John hadn't come home. And that was not like him at all. He had never done that before. Karen had a sinking feeling that something was wrong. Something was seriously wrong. So she got back into her Lexus. She backed up out of the garage to leave the driveway. And when she did, the right rear taillight of her Lexus struck John's parked vehicle in the driveway, and her taillight cracked. That was the same taillight that the prosecution now claims was broken at 12:38. But we have video evidence to have been broken. There is, of course, no video of the taillight being broken at Brian Albert's house. You will eventually conclude that that's because the taillight was not broken there. Importantly, you will learn that there was an eyewitness who arrived at 34 Fairview after Karen got there with John O'Keefe in the early morning hours of January 29th. And that eyewitness, Brian Nagel, who's the brother of Julie Nagel, who was at the after-hours party that night. He had a clear view of Karen's SUV. Brian Nagel confirms that there was no damage to her taillight at that time. Karen was sitting in the driver's seat with her hands at 10 and 2. And Ryan Nagel confirms that while Karen was inside the car, John O'Keefe was not. John O'Keefe was also not outside the car at that time. You will ultimately conclude there's only one other place he could have been. Now, going back to that 5 a.m. video from John's driveway, you will see Karen back up her Lexus and strike John's car at about 5 a.m. when she was leaving John's house to go out to look for him. And you will know that she struck his car at 5 a.m. because you will watch that video closely. You will witness that the wheels and the hubcaps on John's car are jostled and moved by Karen's SUV. And you will conclude that that video depicts exactly when Karen's taillight was cracked, long after she dropped off John that night at 34 Fairview. And you will learn that part of the reason that Karen's Lexus hit John's car was that Karen was panicked at that time. Where is John? Why didn't he come home? What happened to him? And you will learn that she was racking her brain for what possibly could have happened. And like many of us, was worried about the worst. Did I hit him? Could I have hit him? That was what she was saying, both to herself and to other people later that morning when she went back to 34 Fairview. She couldn't think of anything else that made sense. She certainly didn't consider in a million years that someone from within the Albert home could have beaten up John and left him to die on the front lawn. Now, that was over 2 years ago. Karen didn't know then what you will learn during this trial. Karen didn't know that Brian Albert's sister-in-law, Jennifer McCabe, left the after-hours party at Brian Albert's house sometime after Karen pulled away. She didn't know that after Jennifer McCabe dropped off some people elsewhere, she returned to her own home. Karen didn't know that Jennifer McCabe climbed some stairs in her home and eventually made it into her bedroom with her cell phone. Karen didn't know that Jennifer McCabe settled in at 2:27 in the morning on January 29th, 2022, and typed a Google search that she would later delete. 2:27 in the morning was over 3 hours before John O'Keefe's body was found on Brian Albert's lawn. 2:27 was over 3 hours before anyone knew or suspected that John O'Keefe was missing or hurt or in trouble. And at 2:27 in the morning, you will learn that with no one watching her, thinking she was alone with her thoughts, not worrying that anyone would know what she was doing, Jennifer McCabe typed in the following Google search: how long to die in the cold? Now, she misspelled the first word, so the actual search was "how long to die in the cold," but you'll get the point. You will ask yourself, why would somebody Google how long does it take for someone to die in the cold, unless that person knew someone who either was in that situation or would be in that situation? You will question during this trial, who was it who actually did die in the cold at some point that night, sometime after Jen McCabe was asking Google for an answer to her question? And you'll learn that the answer to that question was John O'Keefe. The medical examiner in this case will testify that one of the causes of John O'Keefe's death was hypothermia. John O'Keefe died in part because he was left to die in the cold. Now, the Commonwealth will try to dispute the timing of that Google search. They'll try to claim that there were only 2 Google searches at 6:23 and 6:24 a.m. after John's body was found. But one problem for the Commonwealth will be that we have retained Richard Green, one of the leading computer forensic experts in the country. Rick Green has forensically analyzed Jennifer McCabe's phone, both manually and using every appropriate type of computer software to solve this issue. Rick Green will confirm for you that Jennifer McCabe did indeed make that search at 2:27 a.m. And another problem for the Commonwealth is that you will hear and see other evidence that will confirm that Jennifer McCabe is lying when she denies making that Google search at 2:27 a.m. You will conclude that before she went to bed, if she went to bed that night, Jennifer McCabe wanted to know just how long it would take for someone to die in the cold. And a big question in this trial for you will be, when was John O'Keefe left to die in the cold? I expect the Commonwealth will try to persuade you that he was left there sometime around 12:30 a.m. because they're going to try to prove to you that Karen Read hit him and that his body stayed there the entire night until first responders arrived at 6 a.m. and his body was taken to the hospital. But you will learn that there are big problems with the Commonwealth's theory of this case. You will learn that there were 6 people at that after-hours party at Brian Albert's house, all of whom left by the front door and would have been confronted by John O'Keefe's lifeless body on that lawn if he was actually there at that time. Those 6 people walked out the front door to 34 Fairview, walked to their cars either in the driveway or parked in front of the house. Brian Albert's sister-in-law, Jennifer McCabe, was there. Her husband, Matthew McCabe, was there. ATF federal agent Brian Higgins was there, who was also Brian Albert's friend. Sarah Levinson, a friend of Brian Albert Jr., was there. Julie Nagel, another friend of Brian Albert Jr., was there. And Caitlin Albert, Brian Albert's daughter, was also there. All of them leaving the residence. Each of those people left 34 Fairview in Canton, where Brian Albert lived. Each of them walked out facing the front lawn, where the Commonwealth will tell you that a 6'2" nearly 220-pound big man in dark clothing was sprawled on the front lawn when there was only a dusting of white snow on the ground. He was supposedly sprawled on that lawn, just feet from where these people were walking when they left the residence. And you will learn that not one of these people saw John O'Keefe laying. Not one. And you know who else saw no one laying outside in the early morning hours of January 29th? The snowplow driver in charge of plowing the street for the city of Canton. And this is another big problem for the Commonwealth. You will learn that Michael Proctor, here's that name again, wrote a report where he claimed that the DPW supervisor had told him that Fairview Road had not been plowed that night. Proctor's total investigation on this issue consisted of one phone call and no follow-up. He just submitted his report that simply said the road hadn't been plowed that night, and perhaps thinking that no one else would follow up either. But you'll learn that when it came to finding out the truth, it's not that Proctor couldn't find the truth, it's that he wouldn't. But fortunately, you'll learn that we would, and we did. You'll learn that within weeks after January 29th, we sent our investigator, a former Medford police officer named Paul Makowski, to the Canton DPW to try to get to the bottom of this. Paul Makowski talked to the same supervisor at the DPW, a man named Michael Trotta, whom Proctor claimed had told him that the street hadn't been plowed that night. You'll learn that Paul Makowski found out that Michael Proctor was not telling the truth. You'll learn that Michael Trotta from the DPW told Paul Makowski, our investigator, that the street was indeed plowed that night, and that the name of the plow driver was Brian Loughran. So Paul Makowski tracked down Brian Loughran. He asked Mr. Loughran if the state police or any investigators had ever spoken to him. And the answer came back, no. You will then learn what Brian Loughran had to say about what he saw and didn't see that night, and you will be shocked. Brian Loughran told Paul Makowski that he was driving a big snowplow in Canton that night. You'll learn that the nickname for it at the DPW was Frankenstein, because it had a lot of spare parts in it. It had been careful. He makes sure to check not only the roads in front of him, but also the yards to the side of his plow. He makes sure not to hit a fire hydrant or a tree or an animal, or heaven forbid, a person lying in the snow. He's always on the lookout. You'll learn that Brian Loughran passed by 34 Fairview in his plow, traveling right by Brian Albert's front lawn at 2:30 in the morning. You'll learn that Brian Loughran confirms that at about 2:30, when he went by that house, John O'Keefe was not on that front lawn. So you'll learn that about 2 hours after the Commonwealth claims that Karen Read somehow incapacitated John O'Keefe, an eyewitness confirms that not only could it not have happened, but it didn't happen. But you'll learn that Brian Loughran also provides some other troubling testimony for the Commonwealth. You'll learn that after making that pass at 2:30 in the morning and seeing no body, he showed up again at the entrance to Fairview Road, intending to make another pass down it with his plow. This time, however, at about 3:30 in the morning, he looked down the street and he saw that parked right next to Brian Albert's front lawn, right in the very area where John O'Keefe's body was later found at 6 a.m.,
Rolling
Brian
down,
Loughran saw
baby.
a Ford Edge parked on the side of the road. You will learn that the police have done zero investigation to discover whose Ford Edge that was. You'll learn that members of the Albert family drove Ford Edges. You'll learn that the police to this day claim not to know who was parked right next to the area where John O'Keefe's body was later
Lay
found.
down.
You'll learn that while investigators on this case, including Michael Proctor, completely ignored the snowplow driver who went right by the Albert residence, the defense not only tracked him down and interviewed him, But the plow driver actually took our investigator on a ride back past the residence to explain the precise route that he had taken on January 29th. You'll learn that some other curious things were going on in the early morning hours of January 29th. Curious
Yes,
things
I
that the
did.
police in this case utterly failed to
Algorithm.
investigate. For example, after
I'm sorry, I
people
was
left the
laying
after-hours
down.
party at Brian Albert's house on
Let
January
me
29th,
stop it for a
Brian Albert claimed
minute.
that he had
Right.
no contact with
Right.
anyone.
Okay, after I share everything, and I always went back to StreamYard where I can watch the comments. And I was having problems all day, disconnecting, stopping, this and that. As long as I kept it on the YouTube side, I didn't have no problem. So, like I said, I told you I'm an idiot when it comes to computers. I'm hoping this will get me more subscribers. Because I've seen people, they love stuff like it. There was a guy earlier when I was doing Chad Daybell. He kind of likes stuff. So I picked up another subscriber out of Texas. So I want to thank all you subscribers. I can't do it without you. Let's get back. But
But his wife until he was woken up in the morning. But you will learn that he was ultimately confronted by the fact that his phone records revealed that he had actually placed a phone call to ATF agent Brian Higgins, his friend, the same friend who had been at his house earlier.
what?
That was at 2:22 in the morning.
What?
You'll learn that Brian Higgins called
I
him back
got
17
another
seconds
pan of
later,
water.
and they connected 22 seconds on their cell phones. There'll be 22 seconds there.
All you do is eat.
During long of a phone call.
Why don't you all
You will
listen
consider
to
a phone
Daddy?
call, and there are curious things that were going on during the early
You
morning
could
hours of
wait
January
till
29th.
I get
You
up.
will learn about the following
No.
in chronological order.
You act like
2:12
kids
a.m.
in a
Jennifer
terrible
McCabe
twos.
arrives at her home.
I
2:22
said
a.m.
no.
Brian
You see
Albert
my
calls
glass
Brian
water?
Higgins. 2:22 a.m. 17 seconds later,
I
Higgins calls
just
him
gave
back.
you cat
And Brian
food.
Albert and Brian Higgins are on the phone together
You
for
keep
22
it up.
seconds.
I'm going to whip you with this glass water.
2:23 a.m. Jennifer McCabe climbs the stairs to her
I
bedroom.
told you if you didn't shut up.
2:27 a.m. Jennifer McCabe searches on Google
You're supposed to be the king.
in the cold.
The king cat is
2:30
supposed to
a.m.
keep the
Cloud
cats in
driver
line.
Brian Laughlin confirms there was no body on Brian Albert's front lawn.
You're not doing a very good job,
3:30
Socks.
Brian Laughlin confirms that a Ford Edge was parked right where John O'Keefe's body was later found. The Commonwealth will not be able to successfully dispute any of those facts, yet I expect that they will persist in asking you to convict Karen Read anyway. You will learn that there are other major problems with the Commonwealth's theory. You'll learn that when John
How
O'Keefe
you
was
like
found,
it? Or
he did not look
I'll
like
go
he had been hit
rhythm.
by a
I think
You'll learn
so
that he
far I
looked
ain't
to have
had
been
any
attacked and
problems as
beaten
long
up.
as I keep it
You'll
on
learn
the
that John
YouTube
O'Keefe
side
was
of
a large
StreamYard and not
6'2"
back
man
in
who,
StreamYard.
if positioned behind a Lexus SUV, would have had his torso completely exposed to the rear of that vehicle, including to the taillight. You'll learn that no part of his torso was injured. There was no bruising, no ridges, no scratches, no punctures. You'll learn that his chest and hips and legs were pristine, despite the Commonwealth's contention that he was hit by a 6,000-pound vehicle. The evidence will show that what was not pristine was his right arm. You will take one look at that arm, and you will conclude that a car did not cause those injuries. The injuries to John O'Keefe's arm appear to be consistent with scratch marks and claw marks, marks that make it look as though an animal had attacked his arm. But you won't have to rely just on your common sense when you look at those photos. You'll hear from an expert forensic pathologist who is world renowned, who has personally conducted thousands of autopsies. And he will testify that those marks are consistent with scratch and claw marks and bite marks from an animal, including a German Shepherd. You'll learn that on January 29th of 2022, Brian Albert's family dog, Chloe, was a German Shepherd. You'll learn that Brian Albert has admitted that this dog is not good around strangers. You'll learn that on January 29th of 2022, John O'Keefe would have been a stranger to that dog. And you'll learn that Chloe had been the beloved family dog for the Alberts for 7 years. The Albert family loved Chloe. Strangely,
You lay down,
today, the Albert family doesn't have
you lay down.
anymore. You'll learn that Brian Albert was called to testify before the grand jury regarding this matter in April of 2022, and that he did testify about his German Shepherd, Chloe, during that grand jury testimony. And you'll learn that not long after that testimony, Brian Albert and his family rehomed their beloved family dog. They gave away their family dog. And Chloe, the German Shepherd, is therefore now gone. Now, the Commonwealth will try to take your attention away from all of these troubling facts and try to persuade you not to consider their shocking lack of investigation of anyone else, not to consider John O'Keefe's injuries, not to consider the fact that multiple people left the residence and saw no body, not to consider the fact that the snowplow driver was specifically looking at 2:30 a.m. and there was no body there, not to consider the fact that two people in the house were communicating at 2:22 a.m. but denied speaking to each other for 22 seconds, and not to consider the fact that one of their witnesses, who was also present at the home, was unusually curious at 2:27 a.m. about how long it would take for someone to die in the cold. The Commonwealth will instead try to persuade you that Karen Read supposedly had a motive to kill John O'Keefe because they were not getting along. You'll hear about their trip to Aruba over New Year's Eve and that Karen was upset that John had been flirting with another woman. And you will hear that Karen considered exploring her options after that trip, which led her to a get-together at one point with ATF federal agent Brian Higgins, although that never went anywhere. But you'll also hear that in January of 2022, after the Aruba trip, and not long before January 28th and 29th, John O'Keefe was making long-term plans with Karen, including a family trip with her and the kids, and also another trip with Karen and another couple for months into the future. And you'll see video of how John and Karen were interacting on the night in question. You'll see for yourself how they looked at each other from the video at the waterfall that night. Nobody who saw them that night saw anything wrong. There was nothing wrong. I mean, like any couples, occasionally they would bicker or disagree. But you will hear zero evidence of any domestic violence in that home whatsoever. John never raised a hand in anger toward Karen, and Karen never raised a hand in anger toward John. That simply wasn't who they are. You will conclude the notion that Karen Read chose the start of a snowstorm to suddenly become violent out of the blue for the first time and intentionally kill her boyfriend by hitting him with her car and leaving him there with a house full of people inside is patently ridiculous. You will also learn that what's not ridiculous is that someone, not Karen Read, ambushed John O'Keefe. Somebody probably didn't mean to kill him, but somebody went too far. You'll learn that Trooper Proctor failed to investigate motives that other people had to harm John O'Keefe. You'll learn that Proctor failed to investigate anything or anyone who was in the Albert residence that night. You'll learn that he failed to investigate the antagonistic relationship between members of the Albert family and John O'Keefe. You'll learn that apparently nobody investigates the Albert family of Canton. Remember, on day one, Trooper Proctor was asked whether the homeowner, Brian Albert, would catch a lot of grief. And Trooper Proctor himself said it. Nope. Homeowner's a Boston cop too. So folks, the trial is now about to start and the witnesses are about to start testifying. On behalf of Karen Read, I ask that you do two things during this trial. First, I ask that you pay attention to all of the evidence. The way trials work, the prosecution gets to present its case first. They conduct their direct examinations first. So we respectfully ask that you wait for us. We will get to cross-examine their witnesses, and you will find that cross-examination is the key that unlocks the truth. Wait for us. You'll be glad that you did. Second, I ask that you keep your eye on the ball. You have one job and one job only to do during this trial, and that job, quite frankly, is not to solve this case. Your only job during this trial is to determine whether the Commonwealth, the prosecution, has proven to you each and every element of the crimes they have charged, beyond a reasonable doubt, to a moral certainty. The prosecution will fail to prove this case to a moral certainty. They will fail to prove this case beyond a reasonable doubt. You will reasonably doubt their case because their theory of the case does not make sense. You will reasonably doubt their case because Karen Read was framed, and the evidence shows that, despite the fact that the police never ever investigated that angle of this case at all. Because the prosecution will not prove their case beyond a reasonable doubt to a moral certainty, we will stand before you again at the end of this trial and ask that you find Karen Read not guilty.
All right. Thank you very much, Ms. Giannetti.
Or may we approach you at sidebar?
Yes.
Okay, just on what he talked about and the prosecutor, I done got my mind made up. I'm giving you my opinion right now, not guilty. But I'm going to watch, that's my prediction, not guilty. You know, I'm going to wait on the evidence. So let's get back to it. So I say that would be all until
And Kaylee and Patrick, about how old are they?
I went a little bit too far. So So stop sharing. So I want to thank you all. Well, 2 hours, Lordy, that'll probably be some more tomorrow. So I want to thank you all. I can't do it without you people. It says it's 73 degrees outside. So I'm going to get off of here right now. I hope, like I say, hit the thumbs up, hit the subscribe bell. Let me know in the comments how you all like this. Is that what you want me to do? I know I'm nobody important. I'm not like the expert, the umbrella guy. I'm not famous. There's some people that don't know about this channel. So I want to thank you all. Remember, people, the ones that got the YouTube channel, that got over 5,000 subscribers or more, or 1,000 and over. Remember when you started, how people that helped you out. And just remember, help people like me. It's getting started. Over 300 videos, and I've done too many videos. I see one person make one video, got over 5,000 subscribers. I've seen people that been on 30 days, got over 25,000 subscribers. I've been on about 2 weeks before Christmas. Well, I got a little bit over 250 subscribers. But I want to thank TB. You all said, who's TB? It triumphs beware. So I might do a video of TB, what was talked about last night. I know I don't have many that's subscribers, but I know there's people sitting in the background it's watching. And, since this, what TV talked about last night, I believe it's down in Texas. It does with another YouTuber. And I figure if I can share that video with you all, that will help this guy out. It's in Texas. He's been in jail, I think, a little bit over 9 months, close to 10 months. And I want to share that video because I like helping people. And if that gets me a few subscribers, it's okay. But God wants me to help people out. So that's what I'm going to do. Maybe later on tonight. It depends who's be streaming tonight. Because I like to watch the DUI guy. I like watch the Umbrella guy, Megan Fox, the writer, MG Law, and the ugly one, the expert. That'd be nice if I could get, on their studio, where people gets to meet me, like Megan Fox, the Umbrella Guy, the Expert. I know I'm nobody important, but if I get that many subscribers, I'm not gonna forget where I come. I'm gonna help everybody out I can on YouTube. I want to say bye to everybody. Thanks for coming to Tom Cartwright 4375 on YouTube and WTSC Channel 11 News Media. So I love you. Hit the thumbs up, hit the bell, and I might teach some people about StreamYard. People, it's like me. It's slow up here. I could have done it without TV and a couple other people. And like an idiot, I could have done it long time ago. Hit the present, then share this and that. But TB is a good person. Triumphs beware. I might share his video tonight. It depends what's going on about 8 o'clock. And that guy in Texas needs help. So if I could put it on my YouTube channel and share it on my stream to help that young man out in Texas, it's worth it. That's what YouTube is all about. The biggest media platform out there, like a TV. So I want to thank you all. Oh, I forgot to do number 1. Remember this, people. That means it's the end of the show. God bless you. Hit the subscribe bell. Thumbs up. Share it with your friends. Tell your friends. Let me know in the comments how you like a few videos on court process. God bless you all.